South Africa is famous for its rich and diverse cultural heritage, and we recently celebrated our Heritage Day on the 24th of September. I took the time to take my daughters out camping and just to celebrate the great tradition of South African outdoors, having a braai. And it's also really a celebration of our ancestry and our customs as well. And as we celebrate such days, and as the vaccine rollout continues, while employees grapple with the return to the workplace policies, the question around the donning of religious, cultural, or political clothing and other symbols, I think, once again rises to the fore. And we saw a recent decision of the European Union's Court of Justice, which, although not binding in our South African court, certainly offers useful insights and considerations for employers who endorse a policy of neutrality in the workplace. I'm joined now by Fiona Leppan, who's the Director of Employment Law Practice at Cliffe Dekker Hofmeyr. Fiona, welcome to the show. It's a very interesting topic, this, and I sometimes grapple when my daughters go to school, what is South African heritage? Do I just drape them in the South African flag? And their Zulu and Xhosa friends have such colorful heritage, so much simpler, I think, sometimes. Can you just talk us through what the ruling was? Because I believe the court found that European employers can actually ban workers from wearing any visible sign of their political, philosophical, or religious beliefs.
Thank you very much. Yes, it's an extremely interesting decision, bearing in mind, and I'll call it the European Court of Justice for short, is usually called upon to make a set of recommendations. So member states in the European Union, if they do have to grapple with something as unique as this, may approach the court for its guidance. So it set out a number of recommendations in that regard, central to which were two cases that emanated from Germany. And the first one was an employee referred to as IX versus her employer, Wabe, where the employer was running a number of different creches for young children, the population size 3,500 across Germany, children that is. And the issue there was the employer wanting to introduce this policy of neutrality because it said it wanted to ensure that the parents of the children, their particular needs and requirements had been addressed. And what they were actually dealing with in that regard was a concern that if the teachers are coming into classroom contact with children and with the parents in their obvious daily interaction, that if they're wearing their religious adornments, that's going to in some way negatively influence the children. It would upset the parents who have a particular religious culture and belief at home, and they didn't want children to be exposed to this social contradiction. But what the court said is a policy of neutrality might be possible and it might indeed receive endorsement, but it would have to be justified. One of the justifications that it looked at is that in the past, in this particular environment, there had been social discontent. It had led to a level of unrest, difficulty in managing the school, etc. So there was a historical angle to it, which then justified why they wanted to look at this policy in particular. And the court said it believed that was possible, provided that objective justification was in place, so that social tension, etc., would have to be something that the employer is put on terms to prove.
The key word for me is objective there.
Yes, definitely. So there'd have to be facts to support this. Now, right. What about in South Africa? Do we have something similar to this? Now, admittedly, not immediately in a workplace setting, but we had an excellent judgment from our Constitutional Court a few years ago. Our then Chief Justice, the late Pius Langa, wrote a very rich decision where he was dealing with a school pupil who was of the Tamil Hindu religion, who wanted to come to school wearing her ear, or rather her nose stud, which was a tiny gold stud in the nose. And she was banned from doing so because the school rules said no jewelry. Mm-hmm. yeah, and no conspicuous jewelry. And that went as far as I say, the Constitutional Court, where the court said, look, what harm did this have? If you're going to advance this theory that you don't want any tension in the schoolyard, one child wearing a particular religious adornment versus another, court actually said, don't you want your school children to embrace the differences in our society and the different cultures in our society, the different religions in our society? And actually said something that I thought was really very pertinent. The judge actually described this as a display of religious and culture shouldn't be viewed as a pageant of or rather a parade of horrible, but rather a pageant of diversity. In other words, giving full recognition to the diverse cultures in South Africa and the different religions. And said there was no harm. This wasn't going to in some way impact school uniform usage in schools. It wasn't a breakdown these cultures. In fact, it was the learning curve for people to embrace diversity. And that's why he used that term. Don't see it as this parade of horrible, which of course goes back to the USA and New England, where you had parade and processions of people wearing comic or grotesque outfits. He said, don't see it that way. See it as a celebration of our diversity in South Africa. I thought that was a very rich learning for our different workplaces, because are we seeing this sort of rigor by employers in South Africa? We have a very good case there with Rastafarian religion, pop crew in the prisons a few years ago. And the issue was the employer imposing a rule, and the rule was no braids, cut off the dreadlocks. And the Rastafarian prison guards said, but why? Because what was really very interesting is the women wearing braids in the same job capacity were not subjected to this rule. So the employer was put to the justification, well, why do you want these dreadlocks to be cut off? Why are they taboo in the workplace? And the employer said, well, if we're going to allow this, it might mean prisoners grab hold of the guards, the prison guards, and pull at dreadlocks, pull at hair, and that might give them the opportunity to escape from prison, which I thought was a rather bizarre thought. Then they put up a different angle. They then said, well, it would mean that those wearing dreadlocks might be associated with an opportunity for prisoners to gain access to dacha. But the problem in that case is the employer couldn't prove these somewhat weird theories that he came up with. And that's why this was viewed as being discriminatory. So there was direct discrimination on the basis of gender, because it was only impacting the male prison warder, not the female. And of course, indirect, because it's a rule, no dreadlocks, supposedly, but at the heart of it was disadvantaged by a particular group who wished to practice their religion. So that was the way the Constitutional Court also ruled in that matter.
And what I love about the reasoning used by the Constitutional Court is, I think philosophically, it runs to the very heart of what we're trying to do in South African society, given our context and our history. We need to be inculcating a culture of tolerance and a culture where we celebrate each other's cultures. So if we're aiming and striving for a sense of neutrality, for fear of offending someone based on your religious or political or cultural symbols, then how are we ever going to integrate and develop and inculcate that tolerance? I think it's a very neat way that the Constitutional Court handled that. But coming back to the employment situation, given what you've just described, can an employer actually prohibit the wearing of any kind of religious, political, or cultural symbols on the grounds of a subjective intention to remain neutral in the face of your clients or customers?
No, I don't believe that that's going to pass muster in our courts, largely because our courts have said that differentiation shouldn't be based on exclusion, stigma, or marginalization, and they actually steer away from absolute neutrality. Now, you could have a situation in an employment context where an employer has to impose an outright rule: no jewelry, no loose clothing, and that type of thing. Now, where am I going with that? You'd have to have an inherent requirement of the job that warrants that. If I take you to the Occupational Health and Safety Act, and in particular to general machinery regulations, or one of the regulations specifies no loose clothing, no loose hair, no jewelry, no key rings. Why? Because if you're working with moving equipment and machinery, and it could get caught in that moving equipment, you may harm yourself or others. Now, that's a very good justification. It's objective, it applies to all, and it's got this rational reason why it exists. Safety, of course, being so important in the workplace. That's, of course, a fairly extreme example, but it gives you just the sort of justification that would be necessary in order for you to support such a rule.
So it really has to be objectively justifiable in order to hurdle that particularly high bar. Now, what form of recourse do employees have if they feel they have been unfairly discriminated against on the basis of their clothing?
First, what has happened in our case law is obviously the employees would refer such a dispute to our statutory conciliatory bodies such as the CCMA, bargaining councils, etc., and make their complaint, and there would be an attempt at conciliation. Where they are successful in resolving the dispute with the employer, that is likely then to be referred to the Labour Court, which would then have to adjudicate such a matter with particular reference to our constitutional framework, but more importantly, the Employment Equity Act as well. And absent this inherent requirement of the job, such as the one I've explained, well, that's going to be a difficult one for the employer to fight past. But importantly, if employees were to raise religious, cultural norms, etc., that they're relying on, and they're saying as being the subject of them being discriminated against, and the employer has to show that that is fair discrimination, the issue is that they must be able to show the employees that the cultural or the religious belief they hold is genuine. Now, there is one matter where it boiled down to being somewhat contrived, because the employees said they were of the Nazareth group of faith, and in a security environment, they were actually employed as security guards. The employer wanted to ensure that everyone dressed neatly, that they were either clean shaven or beards were trimmed, because they wanted to project that professional image to their customers. That was their selling point. And this particular group of security guards said, no, this is part and parcel of our religion. We don't shave, we don't trim beards, and it's out of the question that we're going to follow this rule. But they had to bring forth expert evidence to demonstrate that particular reason in their faith, which had this rule that they had to comply with because it was compulsory. But the expert they led, unfortunately, was crushed in cross-examination. He had no source for the rule that they were looking to espouse. In fact, there was some tension in terms of what rules they would obey and what they would not, because in that religion, so it was said, work on a Sunday was absolutely not acceptable. Yet these guards worked on a Sunday, they wanted the overtime pay. So it left the court saying, but hold on a moment, this is selective adherence to a religion to get around a workplace rule. That will not cut it in our labour courts.
And speaking of
so it must
religion,
be a genuinely held belief. Yes.
Absolutely. I mean, one can't concoct religions and say, well, certain Rastafarians celebrate 420, so we've got to knock off at 420 every day. It has to be backed up by some religious text, I would imagine, and then one has to demonstrate that you are a devout follower of all and not cherry pick just what suits you. Now, taking time off for religious holidays, I've always found this a bit of a curious one, because we live in a largely Christian society in the workplace, and we know we often given time off for Easter or Christmas. What about other religious celebrations? Because we certainly can't be discriminating based upon one's religion.
This is something employers have been grappling with. The Public Holidays Act is actually very interesting because you can swap out certain public holidays. So if there had to be one that, for example, a religious group, and I'll take the Muslim religion, if I may, because they celebrate Eid. It's a very important occasion for them. So they take that day off. They might then ask the employer, well, can I take that as leave, or may I negotiate that as part of my contract as my being allowed a day off? If it creates any issues in the workplace, it might well be that the employer says, well, would you be prepared to swap with a different public holiday? Because we do have industries that operate 24/7, etc. So they might then be accommodated in that way. And reasonable accommodation lies at the heart of the very debate you raise. So in some of our case law, that has certainly come to the fore, where the courts have said, well, if someone is celebrating Eid, why don't you let them work in for that time that they would like to use to celebrate their religious beliefs, because it's not a statutory public holiday? Or would you be prepared to swap out with a statutory holiday? You agree to work that at no extra pay because we've endorsed your day of Eid. And I do think it comes to what's sensible under the circumstances. And employers are doing that. And it's not unheard of in terms of collective agreements as well that are concluded in the workplace to adjust to these sort of requirements.
Common sense. Good to see common sense prevailing. Now, I think we're likely to see, based on the evidence so far, based on who I've spoken to in HR department CEOs, this hybrid model when it comes to South Africa's workforce now after the pandemic. You might be able to choose how much time you're at the office or how much at home, but I don't think it's going to be either one or the other. What are some of the things that employers must consider whilst enabling employees to continue to effectively work from home?
I think the emphasis on the quality of the work standard, and that the work is done professionally, on time, in accordance with the employer's requirements. Unfortunately, I'm investigating a matter currently where the lady was given this opportunity to work from home and clearly abused it. Couldn't be reached, wasn't available on laptop when that was one of the requirements. And work was not getting done. And when they tracked her down, unfortunately, she'd gone off to get married, and just basically abandoned ship. Now, that you cannot have. And you certainly hope that that is rather an extreme example. But it does mean the employer has to ensure that it's getting its full output, and it's going to have to be able to measure that. But I agree with you that the hybrid model is likely to be with us into the future. I think for working mothers, it's becoming a brilliant opportunity for them because they can adjust their family responsibility alongside their work responsibility. And if they get up earlier to work, adjusting to take children to school or fetching children, and the day's work is done to the employer's satisfaction, then why not? Because this was a debate that was creating all sorts of issues before the pandemic, because more and more women were asking for these sort of indulgences, and the employer, in that normal office environment that we were so used to, was saying, no, but you must be at the workplace. Well, the workplace now can be anywhere. We as a firm have certain professionals working for us. The one's being based in India, another in Sweden. You wouldn't know the difference because technology has really aided that opportunity. And I think measured correctly, managed properly, I think it gives the working mother fabulous flexibility, as well as men in that situation. We mustn't forget that it's not always the mother that might be the lead role in looking after the little ones.
I was about to say, I've just spent the last week with my little ones who are on holiday, and working flexibly has allowed me to, between interviews, between going into the business day studio, spending a bit more quality time with them, taking them to the park, taking them bike riding. And I do think, and I'm a firm believer in the nuclear family as a central building block of healthy, functional societies, that this will have a net benefit on society. Better adjusted children into the future can only be a good thing net. So I do hope that employers are taking this on board and seeing this as the big opportunity that it is. Now, speaking of opportunities, there are also some very thorny issues in South Africa at the moment. And I think this issue of mandatory COVID-19 vaccinations in the workplace has been something of a contentious topic. I've had both of my Pfizer vaccinations, but I also know people within my own circle who are vehemently opposed to the vaccine. What has CDH seen on this topic? Have you seen an influx of cases? And what does the law actually say on this matter?
So what we have seen from a practical angle is more employers seeking advice on a vaccination policy and best able to drive it after consulting with their employees as to what is it that persons want with this hybrid model with some degree of a return to work. And what one's noticing is those employees wanting to return to work, having a more structured environment, because some do prefer that. And in some instances, that's what the work does require. You can't do everything from home. But employees are coming forward to say, well, we want to be able to return to an environment where everyone's been vaccinated. We don't want to be exposed should an unvaccinated person pose a threat in terms of any new variant. There's some suspicion with that. So to try and accommodate this, what does an employer try to do? Drive it through policy, certainly. There could be particularly some work environments that would warrant mandatory vaccination. Particularly looking at certain manufacturing lines where on big transformers where there's a lot of welding work, those team of welders very often have to work side by side. There's no room for that social distancing. It just can't work. So vaccination helps to bring down the exposure to the serious side effects of something such as the COVID virus, as we have seen it. And this pandemic has been brutal in that regard. But what about an office environment? Other types of workplaces where employees can come back and you can have social distancing. The argument's going to be, well, what were you doing when COVID did hit? You did have social distancing. You had the sanitizer protocols. Why can't you continue with that, whether the person's vaccinated or not? So there are some employers looking at the mandatory side of it, but in relation particularly to the inherent requirements of the job concerned, as opposed to a blanket policy in that respect, because it might be more difficult to enforce.
Mm. I think very difficult from a culture perspective as well, inside an organization where you perhaps have something slightly more decentralized and laissez-faire, and you reward entrepreneurialism. To enforce anything from the top down is likely to be met with resistance. That's not very good for culture inside the organization. So chatting to various CEOs about how they're going to be tackling it, they've also said, well, we need to be mindful that there are risks if you remain unvaccinated. So we might then have to place you in another part of the firm or organization where you pose less of a risk. And in that way, things do become a little bit more uncomfortable for you. So there is a bit of soft pressure that I see being employed as well.
I think the soft pressure is also coming from external factors. Your inability to travel without the vaccination passport. In France, more recently, you're not able to gain access to certain restaurants unless you can show you've been vaccinated. So I think that pressure is going to build. I certainly do. But as we see our numbers dropping, as we see our society coming to grips with pandemics of this nature, I think more and more are going to say, but there's value in the vaccination. Our hospital admissions right now are less than what they were a few weeks ago when we were emerging from this disastrous third wave. So it's giving impetus to the argument vaccination is the way to go.
Absolutely. Well, Fiona, what the old Chinese curse goes something like, may you live in interesting times. I believe we have been living through extremely interesting times, and particularly when it comes to the world of work and employment law. So thanks for taking us through a tour of some of the more interesting elements of your area of expertise over the last while. It's been a real pleasure sharing your insights here on Business Talk. Take care.
Thank you very much.